Welcome to this course on competition policy. So this is first lecture. So my name is Gijsbert Zwart. So I'm working in the economics department on the 7th floor in Duisenberg building. And I'm teaching this course with Allard van der Maden. So this is 2020, so that's why we're doing this on video. So what we're going to do in the course is, well, today in particular, is what I'm first going to do is to introduce the topic of competition policy and competition theory. And I'll give a little bit of context, institutional context on how competition policy is, what it looks like basically in practice. So I have a little bit of a look at the relevant legislation here, because that's a necessary background to understand cases, actual cases. Then I'll spend a little bit of time in discussing the organization of this particular course for this year. And then we'll review a little bit what is competition, or particularly why do we care about competition, so what are the benefits of competition, why would we like to protect competition. And that's sort of a review basically. So finally we'll have a first look at the actual contents of competition policy, and most competition policy cases actually start with defining, well, what market actually are we looking at, or in other words, we have to define what's the relevant market. So we'll go into that as well. So to start with the introduction, so I think competition policy has been topical for a long time already, but perhaps not very often more than now, than today, in these past few years actually, which a very lively debate has sprung up across the globe basically on the power of competition policy, of competition law, to rein in basically the potential market power of players, in particular in the digital arena. So you see here a couple of recent developments. So on the left you see the European side. So 2 years ago, I think it is by now, there was a big case against Google, the Google Android case in particular. Well, in fact, there have been a number of cases, at least three actually, against Google in recent years. And the second of these was the Google Android case, in which Google was fined 5 billion, which at that time at least was a record fine for violating antitrust law in Europe. And particularly this was related to the combination, the bundling, or the tying actually, of Google search, Chrome search, the Chrome app and Google search to the Android operating system in the mobile market. So that was a big step in the EU. So the US were a bit slower to follow, but right now actually you see something unique, which is agreement between Republicans and Democrats actually, that there is something to do here in the in developing or updating or modernizing antitrust law to deal with digital platforms like Google's, like Apple's, like Facebook's, etc., like Amazon's. So you see here a very recent, a couple of days ago, actually a quote from Financial Times, or actually a headline from Financial Times, about the Google lawsuit, the opening salvo in a battle to restrain big tech, which was a coordinated action by the Department of Justice and the FTC in the United States, to actually do something to see at least to what extent their powers, the competition policy powers, their competition law powers, reached again in dealing with Google. So this particular first case, it is going to be presumably is going to resemble presumably a little bit the EU's case against Google from 2 years ago. But this is the first one to come, that's very clear. And there's a lot of discussion also across the houses, the House of Representatives and the Senate in the US on what do we need to do to deal with competition power abuse of digital companies. Do we need additional legislation, or can we do with what we have today? So that is about topicality of the issues that we are going to discuss here. So nothing to complain about in that direction. So what we are going to do now is discuss. I want to do a little bit of discussion about the institutional context, particularly in Europe. So we are in Europe here. So the dominant competition law enforcement here is from Europe, not from the national enforcers, but Europe is here the leading power, and the national enforcers follow suit. So what is competition policy in the EU? What does that look like? Well, first of all, the competition policy in general is a combination of law and economics. So we need to know indeed a little bit about law. So we are going to, of course, this course is in the economics department, so we're going to focus on economics, but we are going to have a look at in particular various cases, and it's necessary to actually understand a little bit, what does the law in this, what's the legal context of these cases. So the EU has, of course, lots of goals, but some of these are in the area of competition, and particularly the EU objective in the area of competition is to prevent, well, loosely speaking, to prevent the distortion of competition. At least that's what they proclaim themselves. Why? Well, the goal here is, or the vision is, to have a free and dynamic market. That's what EU is about, having this large European market of products, and the idea is, well, this is only going to work if there's free competition in this market, because that's going to promote low prices for consumers and lots of high quality and lots of innovation by firms. That is a result from vigorous competition among firms. So in the end, what we would like to have is better economic welfare. That's what the EU basically was made for, and one of the reasons the EU was created in the first place. So how does the EU do this? Or what is the legal the legal underpinnings of competition policy? Well, they are laid down in these in the treaty. Well, the latest treaty that deals with competition is actually the Treaty of Lisbon Treaty back from 2007. And particular competition policy here is the policy rules are put in are part of the so-called Treaty on the Functioning of the European Union, TFEU. So this is a very large treaty with lots of articles, but particular articles 101 and 102 deal with competition here. So let's focus on those. And actually they are actually inherited from articles from the previous treaty, the Treaty of Rome, which was in place before that 2007 update of modernization of the European law. So Article 101, the first one, is a ban on anti-competitive agreements. So in particular, what is an agreement? Agreement is an agreement between different firms. So what is banned outright is price fixing or cartels. So you're not allowed as a bunch of firms to come together and agree on, we're going to charge these prices, so we know this. So that's one type of agreement. That's actually not a type of agreement that we're going to look at much in this course. If all is well, you've seen a little bit of that in your previous course on game theory and competition. What we're going to look into in this course much more is vertical agreements. So agreements between upstream firms and downstream firms. So here the rules are much more nuanced than typical price fixing, which is basically per se forbidden. So in particular, there are various good reasons to have agreements on upholding quality in production, supply chain, for instance. And that's also why there's lots of exemptions, and particularly there are exemptions for small firms. So if you, as a bunch of firms, or the two firms in particular, who are writing a particular agreement, have a market share which is below 15%, then generally speaking, you are exempted from this rule. So you don't basically need an okay from the EC on having your agreement, and this is actually called the de minimis rule. So this regulates or basically passes this 15% threshold in market shares below which you don't really have to worry, except for some behaviors, some types of agreements which are per se forbidden. So you can actually never ever have such agreements. And you can think here about resale price maintenance. That's one that's blacklisted, so that's on this list of hardcore restrictions. And also territorial restraint, so you cannot, well, it flies in the face actually of the European idea that you might restrict companies from selling in particular countries and not in other, while they are allowed to sell in other countries. So you cannot have any restrictions saying, well, you're a German company, you're not allowed to offer my products as a retail seller to Dutch consumers. That's strictly forbidden, even if not from competition concerns, from this European idea vision concern. So that's 101. So 101 deals with agreements, anti-competitive agreements. And it used to be called and if you look at the book by Malta that you might have, it's actually referred to as Article 81, which was its number of basically the same article in the previous version of the treaty. And if you go further back, it would have been Article 85. Even. So you might see very old references to Article 85. Again, this would be a ban on anti-competitive agreements. So then the second one is Article 102. So Article 102 is a ban on abuse of dominance. So what is dominance? Well, dominance is related to a dominant position. So it's defined in this article as, well, let's read this closely, a position of economic strength enjoyed by an undertaking. So an undertaking is basically a firm, right? An enterprise. So a firm which has economic strength, which enables it to prevent effective competition being maintained in the relevant market. So it helps to reduce competition, basically to hinder competition in the market in which it is active, by giving it the power to behave to an appreciable extent independently of its competitors, its customers, and ultimately of consumers. So what this basically says is we want to prevent companies having significant market power. That's what we would say in economics, and this is basically the legal phrase for having significant market power. So if a company is dominant, if it has on its own significant market power in a particular market, particular product market, or in a particular geographic market. But the second word in this ban, apart from dominance, it's about companies with market power. So having market power itself is not forbidden, but what is forbidden is abuse of that market power. So what is abuse? So abuse basically falls in three categories. The first one is exclusionary abuse. The second one is exploitative abuse, and the third one is discriminatory abuse. So exclusion basically relates to preventing competitors from competing effectively in your market, basically for instance, by making it very difficult to enter those markets in the first place. So that's going to be exclusion. That's actually going to be a particularly important topic for this course. There's a second abuse is perhaps what you would think of more easily when you think of companies with market power, in particular monopolists, which is exploitative abuse. So exploitative abuse means you're exploiting the people you're selling your product to. How? Well, for instance, in particular by raising prices above competitive levels. So this is what we economists are sort of taught in the first place when we think about monopoly. Well, this is about high prices. Well, of course, lawyers also and policymakers in particular also care about high prices, but it turns out to be fairly difficult actually to bring cases and to make them stick actually that rely on abuse, on exploitative abuse, or on monopoly prices. And the reason is, of course, that's fairly difficult to establish, which prices are exactly too high. So how far can you go? What are actually your costs? It's very hard to actually measure costs in in a convincing way that is convincing to a judge. So exploitative abuse is forbidden, but you see much fewer cases uh, revolving around exploitative abuse than around exclusionary abuse. Exclusionary arrangements are sort of much more common in the cases that we're going to look at. So the final one is discriminatory abuse, which basically comes in, well, we can think of this, for instance, as charging different prices to different types of consumers, particularly, for instance, in different countries. So there's a limit to what you can do in discriminating among consumers in different markets. And again, here there is, part of this is related to the vision of the EU. We have one single market, so we want to forbid companies to actually charge different prices in different member states. So we as economists, we know that actually discriminatory prices is not always bad for welfare, right? So you know that you can actually increase efficiency by having some price discrimination. So the law here is sort of stricter. Discriminatory pricing is something that's frowned upon per se, basically. So that's 102. That's about abuse of dominance. So these are two important types of cases that we will have a look at. So the agreements between firms, particular vertical agreements, and also exclusionary behavior by a particular firm which has market power. The third issue that is going to be important that we also have a close look at is mergers. So mergers are actually not themselves directly in this TFEU agreement. There's a separate so-called regulation, merger regulation, which dates back from 2004, which is a separate piece of legislation, but which again gives the European Commission powers to either okay mergers or to ban them or to only allow them with under certain conditions. And what this merger regulation tells firms and tells the judge and the Commission is that concentrations, so concentrations is the legal word basically for mergers and takeovers, where two firms basically fuse together. So concentrations which would significantly impede effective competition in the common market, so in the EU, or in a substantial part of it, so in a number of member states. Well, how would it impede competition? In particular, through the creation or the strengthening of a dominant position, so by increasing market power, as we have learned. Such a concentration, so such a merger, must be declared incompatible with the common market. So that means the EU, the European Commission in this particular case, can actually ban particular mergers. So this dates back to 2004, so that's just after the book by Malta actually. So if you look in Malta, he sometimes anticipates this modernization of the merger regulation. Well, this is it. So what does this modernization include? Well, in particular, the idea of what we want is significant lessening of competition. So we want to be able to forbid a merger, prohibit mergers that result in more market power. What it used to be was mostly restrict mergers to monopoly or to something which was called joint dominance, or which was actually a little bit murky, I think. So now it has become, since 2004, a lot more clear that a merger which results in an oligopoly with, say, duopoly, for instance, which we as economists would say, well, that's pretty much a pretty big amount of market power. Well, that's now also explicitly falls under this merger regulation. So that's mergers. We're going to have a look at those. The final pillar basically under competition policy in the EU is state aid. So member states, usually financially helping certain companies and thereby potentially distorting competition. That's something that the EC has something to say on, but we will actually not look at that in this course. So we'll keep strictly within the competition arena, basically. So how does the Commission go about these cases? Well, so it is the European Commission which handles these cases, in particular the directorate related to competition, the competition directorate. What they do is they bring the case, and ultimately this results in a decision. That decision might take a long time if it's about abuse, this article, or about market power in general and the agreements, so the 101 and 102 cases. Might take years easily. For mergers, that's a different question, of course. So if you want to merge with another company, well, you don't want to wait for 3 years because then your business case might have vanished. So there's a tight timeline in this case of basically a finite number of weeks, and there's some extensions that are possible, and I'll discuss those when we get there. But so for mergers, typically are dealt with in a much faster track. So once this this decision has been made, has been published, of course, firms might not agree with it, and then they can appeal this decision in the EU law courts. And in particular, there are two law courts which deal with these decisions. The first one is called the General Court. So you might see some decisions of the General Court, which previously, more or less also, I think before 2007, was called the Court of First Instance. And the highest power, the highest authority here is actually the European Court of Justice. So what these courts may do is they may agree with the Commission, but they may also annul certain decisions, or they may refer them back and tell the Commission, well, you really have to sort of do your homework again, because this or that part is actually not sufficiently argued. So, and then it actually goes back. So both outcomes are conceivable here. So that's EU law. We have, of course, lots of member states inside the EU, which typically have national law, but this national law basically is a reflection of EU law. So these, what do the member states do themselves? Well, if there's just a national case which only involves companies which are active within that particular member states, small cases essentially, smaller cases, they would be handled by the national authorities. It's under the principle of subsidiarity. So if you can handle cases at a lower level of authority, well, please do so. So in the Netherlands, we have the ACM, the Authority for Consumers and Markets, and likewise you have such authorities in other countries, like the Bundeskartellamt in Germany. So they would deal with mergers and also with abuse cases, with dominance cases and agreements in much the same way as the EU would do, but for smaller cases. So the US is an important arena for competition law. So of course they have different law, but it looks a lot like European law in many respects. But it's much older as well. So it's basically goes back to the Sherman Act, which was already established in the 19th century, and at the beginning of the 20th century was there was an additional act, which was called the Clayton Act, which underlies most of those cases in the US. Cases in the US are actually brought either by the Department of Justice, the DOJ, so that's part of the government, federal government, or by this particular agency, which is called the FTC, the Federal Trade Commission. So we might see some of those terms also coming back, in particular in some of the papers that we're going to have a look at. So that was the institutional context, so just to know that this exists basically, and we are actually going to have a look at some of the actual cases that were written by the EU in our case. And you see the intertwining, if you wish, of all the legal parts, the moving parts from law, which is a lot usually. And inside of this, we see the economic arguments that we are going to focus on in this particular course. So the next video, next part of this lecture will be on how are we going to organize this course. So what's this course going to look like this year? So I'll see you there.